Thank you, Your Honor. Your Honor, the first thing I would say is that throughout this incident, at all times, Ms. Incarnacion was acting in the best interest of her children and was acting to protect her children. I would suggest to you that she is in no way a flight risk, which may sound like a weird thing to say from someone who was arrested in Texas, but she was with her children, and she's not going anywhere without her children, and her children are here. As you can see from her record, Your Honor, she has very limited history with the court, a couple of minor motor vehicle matters over 11 years ago. She has no serious record, she has no convictions. She's a person who would tell you that she follows the rules. She's followed the rules of DCF in the past. DCF has been involved with this family in the past. She's completed her service plans at various times. I note, Your Honor, that despite the sort of sensationalism of this case, it is only a misdemeanor. It's only punishable by up to a year in jail or a fine of $1,000.
On each count?
On each count, I understand, Your Honor. And I would say that my client has been in custody. She was arrested on May 7th in Texas, so she's been in custody for a month or over a month, which may, not to prejudge the case, but might exceed any sentence that she would receive in this case, even if she was found guilty. Given her record, I would suggest that at worst, she's facing probation. I would also suggest that this case is ripe for a 3G motion. I carefully reviewed the statement of facts in this case, and I would suggest that there is certainly not probable cause for the charge. And even if there was probable cause, it's not a case that the government's going to be able to prove beyond a reasonable doubt. The reason being that the issue is going to be the notice of the court order and the service or lack thereof of the court order on my client. My client, by law, is the custodial parent of these children until otherwise, and I understand that.
Didn't DCF, and I wasn't involved in those previous juvenile proceedings, but did DCF remove custody of the children from her and grant it to someone else? Physical custody?
So DCF took custody at the care and protection hearing. The issue was
after a hearing, though, right?
After a hearing that my client was not present at. It's an ex parte hearing. It was scheduled for a 72-hour hearing, which is essentially what we would call a two-part hearing or restraint. The police, according to the statement of facts, they attempted to serve her with the care and protection on the 27th and were unsuccessful in doing so. The statement of facts said that my client was aware that DCF would take custody, but not that she was aware of any court order. And according to the statement of facts, they attempted to serve her with this court order on the 27th and were unsuccessful in doing so. There's also some indication in the statement of facts that they had some communication with Mr. Rivera about the court order by text message, and that he had responded to them about something about leaving it in the mailbox. But there's no indication in the statement of facts that my client was aware that there was a court order transferring custody. So I think that, I understand that that's an issue for another day, but I think it's relevant to the bail question because it's obviously relevant to whether my client's going to appear here. And as I indicated, she's not going anywhere without her children. Her children are here. DCF has custody, but they have been placed in the physical custody of her family members. Her mother has the older children, and her sister has the youngest, the 9-month-old. Upon her release, she's going to live with a different sister because she's not allowed to live with the children right now, obviously, because of the care and protection and the DCF involvement. She would live with her sister in Southbridge. And she certainly wants the court to know that she takes this matter very seriously, and she intends to appear to all her court appearances, and she's going to appear at a care and protection case as well. I think, Your Honor, frankly, that this is a personal recognizance case. But I did speak with her family, and they were able to raise the amount of $1,000 for bail. But my official request would be for personal recognizance, Judge. I don't think bail is warranted in this case, but if you decide that it is, they are able to post $1,000.
All right, thank you, counsel. All right, let me just say this. I'm not gonna comment on what the potential sentence is that the defendant may or may not receive. Obviously, she's presumed to be innocent. The only issue I have is whether or not she will appear at a future court hearing. There are several defaults, on her record. I am setting cash bail in the amount of $7,500 cash, $75,000 with surety. If she feels that amount is excessive, she has a right to a superior court bail review. I'm advising her that if she is arrested or charged with a new offense while it's suspending, that her release can be revoked and she can be held up to 90 days or until the case goes to trial, whichever is longer. I know that the co-defendant's coming back in a couple of weeks. I'm not sure if you folks had spoken about that.
He's here on the 15th, Your Honor. That was because I needed to get some discovery to him. I
Okay.
did provide discovery to counsel today on this case, so I don't think that quick turnaround is warranted here. And I believe we discussed the date, which.
Did that, did that.
Judge, we got May 22nd. I'll wait for 30 days.
All right. Do we need to address any pretrial conditions now, or is that?
No, Your Honor. And as I stated, everything that I have, I did provide to counsel today and submitted a certificate of compliance.
No, I saw that, thank you. All right, then, we'll see that, okay? Take care. Pretrial. Do you know if this is staying in the district court?
It's a misdemeanor.
Okay.